when you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Hey, what's up guys? Legal Bro here, back from my honeymoon and ready to get into it. Attorney Reacts channel today, taking a look at YNW Melly's double murder trial and the 10 best clips of the trial to date. Now, I understand at the time of filming this that we are well underway into the trial, but Jaboy has been on vacation and I need to get back up to speed on what's been going on. Let's get into it.
YNW Melly's legal name is Jamel Demons. He faces 2 counts of first-degree murder for the death of 2 lifelong friends, Chris Thomas and Anthony Williams. They were part of his rap group YNW. Thomas went by YNW Juvie, and Williams went by YNW Sack Chaser. A 4th member, Cortland Henry, went by YNW Bortland. Prosecutors say on October...
All right, now remember, that name is going to come back up again, right? Melly and Cortland were allegedly involved in this plot to kill their 2 best friends, right? So remember that name.
October 26, 2018, the 4 men left a recording studio together at 3:19 a.m. They're seen on surveillance video getting into a gray SUV. More than an hour later, Portland showed up at an emergency room with Juvie and Sack Chaser in the SUV. They were dead. Melly was not in the vehicle. Portland claimed they had been the victims of a drive-by shooting, but he didn't have a scratch on him. Portland is charged separately. Melly faces the possibility of the death penalty if convicted, and he's the first person in the state of Florida to face the possibility of the death penalty under a new lower threshold. A recent change in Florida law allows a jury to impose the death penalty by a vote of 8-4. Up until April of this year, that vote had to be unanimous, 12-zip.
All right, so she brings up our first point. YNW is looking at the death penalty, and even worse for his legal team, they don't need to get a unanimous vote anymore. What does the state of Florida require to convict somebody of capital punishment and sentence them to death? Well, those are separate trials, and while those are separate issues to be decided by the jury at separate times, what she's referring to is Florida's state house and state senate has voted, and Governor Ron DeSantis has signed into law that the threshold for capital murder in the state of Florida is no longer a unanimous verdict of 12-0, but it is a 8-4 vote, meaning if you have 8 people that sit on a capital murder case jury and 8 of them determine and find that the defendant is guilty and should be sentenced to death, then those 8 votes are enough to sentence YNW to death. 4 votes could vote against death and he would still get death. Whereas before, obviously, you needed all 12. Otherwise, YNW is likely going to jail for the remainder of his life without the possibility of parole. The other thing, honorable mention, that was part of that bill that she's talking about is that the state of Florida now allows for the death penalty in a non-murder case for those that have been convicted of a crime against a child, certain types of crimes that I'm not allowed to mention on this channel, where the child is under the age of 12 years old. All of this directly stems from the most recent capital case we have here in Florida down there in Parkland. The jury did not sentence the Parkland shooter to death, which obviously prompted all of that legislation.
The week started with opening statements, of course. Christine Bradley is the Assistant State Attorney for Broward County. She gave the opening statement for the prosecution. She described Melly as a cold-blooded killer.
On October 26th of 2018, this defendant shot and killed 2 of his friends. He killed Christopher Thomas and Anthony Williams. So, ladies and gentlemen, I'm going to set out the story and how this unfolded and lay out what I expect the evidence will show during the course of this trial. First thing you are going to hear is that at 4:35 a.m. on October 26th of 2018, Cortland Henry, the co-defendant, shows up at Memorial Miramar Hospital. In his car, he has 2 dead bodies. In the front passenger seat is Anthony Williams. In the rear passenger seat is Christopher Thomas. They are dead, they are riddled with bullets, and the car is full of blood. Christopher Thomas is sitting in the rear there is multiple defects to his body. Anthony Williams, who is sitting in the front, has 2 major injuries. Officer Jessica Amangor is working a detail at the hospital. Cortland Henry runs in, starts telling a story about a drive-by, quote-unquote drive-by.
The prosecution's
All right, so we're in Broward County. We know they get a lot of action down there. They've actually got a police officer stationed at the hospital who's kind of working a detail. I'm sure they get a lot of traffic in and out, probably helps keep people at bay, but she's the one that intercepts Cortland as he runs in and says, "You've got to help my friends, right?" And that's how this story sort of begins, and that's who you're going to see the state start out with their witnesses, right? State's burden to prove that YNW killed his friends, right? And the state is going to start with that timeline of the story. They're going to put on that officer who was at the hospital that night. There are a number of things you're going to see on both sides, right? You're going to see the state paint this picture, right? Of course, it's premeditated. They've already killed him, but they pretend like they haven't killed him. And the defense is going to say, well, look at that. You know, you had your first chance at getting this case right, and you messed it up because you let all these people come in and out of the hospital without figuring out who was who. Very interesting.
says the story about a drive-by is made up and there's no evidence to support it. But there is evidence of a shooting found in another location where cell phone evidence indicated Melly and his friends had been that morning. The prosecution also talked about Melly being in a gang and an Instagram message that they say is essentially a confession.
One individual, and specifically, sends out, and I want to quote the message exactly that you will hear, and says, right after this, "Yo, homie, you good? Let me know something." And so, ladies and gentlemen, this is where context matters. What does that mean? If you work at Google and you say, "My whole floor is coding," that's a good thing. If you work at Broward General Hospital and you say, "My whole floor is coding," that is a bad thing. The context around the messages matters. So in the context of this message, this individual is reaching out, asking if Mr. Demmons is good after he's been tagged in multiple social media posts about this drive-through, this shooting. And Mr. Demmons responds very succinctly, "I did that." Shh.
All right, not great, right? Obviously, that's going to be some of the best evidence that the prosecutor can have, right? If she has any testimony that is the defendant's, where she doesn't have to examine him on cross and she can get this into evidence, the defendant's own words are going to paint the picture, right, for the jury from his state of mind from that time period. What's a little bit interesting about this is, the prosecutor, she's got a super tough job, but I mean, we got to get a little bit more charisma, I think, right? A little more chutzpah. And I'm only laughing because I don't know how many times that prosecutor has said, "Hey, homie," or "Yo, homie." And I'm not laughing at this case. Obviously, it's super serious, but just when the prosecutor says, "Hey, homie," kind of makes me chuckle.
It was the defense's turn. Melly's lead attorney, David Howard, told the jury the state can't prove its case.
That's the first indication that they're just guessing and don't know what they're talking. And that, ladies and gentlemen, by itself is reasonable doubt.
Real quick, I just wanted to say that Attorney Tom / Attorney Reacts content is now on Spotify. We just launched a partnered show, link in the description. Go check it out. Now, back to the video.
You hear that all the time in criminal cases, beyond a reasonable doubt. All right, and beyond a reasonable doubt, you already know this, but one of the examples that I love, one of my favorites, is they say, okay, imagine you had a closed shoebox, a mouse, and a cat in one room, right? There's no windows, there's no way for them to get out, and you close the door, right? And you see, again, that closed shoebox, you see the mouse, and you see the cat, right? And when you close that door, you see all three. And when you reopen that door, who do you see? You see the closed shoebox and you see the cat. And you take a look at the shoebox and there's nothing, right? The shoebox is completely closed. It's beyond reasonable doubt that that cat ate the mouse, right? That's kind of the basic understanding of beyond reasonable doubt. There's nowhere for that mouse to go. He didn't chew a hole in the box. So therefore, the cat must have ate it, right? But now, let's say the same example. When you close the door, you see the closed shoebox, the mouse, and the cat. And then when you reopen the door, you don't see the mouse, but you see a little hole, right? This mouse chewing rat, right? This little mousey chews a little hole in the corner of the box. see the cat, you find the closed shoebox, but there's a little hole, and it's big enough for that mouse to have gotten in. That in and of itself is enough to prevent a finding of beyond a reasonable doubt. Why? Because we don't know if the mouse is in the cat's stomach or the mouse is in the shoebox, right? We have enough evidence, or there is enough evidence to show that we can't prove beyond a reasonable doubt what happened to that mouse. That is what this defense attorney is saying when he says, look, state can't prove beyond a reasonable doubt because of X, Y, and Z. So imagine the state's building this house and the defense is knocking out brick by brick until that house falls over. And obviously the defense is trying to poke as many holes as they can.
Why he would commit such a heinous crime against his own two best friends for no reason. What happened here is that the lead detective, Detective Moretti, saw a video of Mr. Demons getting into a car 40 plus minutes before bodies were found in that car. And then he discovered that Mr. Demons was a rising star. And from that point on, he decided he's the only person that could have committed this crime. Because if you're involved in prosecuting a star, you become a star. This was his big break.
Wow. Great opening by the defense. The state's opening, in my opinion, again, just my opinion, they're both way more experienced lawyers than me, but my opinion of this is that the state's opening was a little bit flat, right? It's a drive-by. The coding example with Google, I don't know. I think we could use one that most of us would probably understand a little bit better. But the defense here is painting a picture, right? What's the picture? A hammer's always looking for a nail. He found his guy, and this was his ticket to stardom. Once he found out who YNW Melly was, he knew who his man was, and there was nothing that was going to shake that, right? He had bird dogged that, and once he got that bird in his mouth, you were not shaking him loose. YNW Melly is our guy. Stop the chase. We know who we have, right? Unfortunately, that is a picture that resonates with a lot of juries, right? Because of the fact that there are all of these other leads, or there's other evidence, or there are other people that could have been involved. But sometimes in some of these cases, you have officers that are very fixated on one individual, and they have this sort of motive in their head of why this happened and who would have done it, that their blinders are on and they miss everything. And I think this defense attorney does a great job of capturing that, which is why I think this opening is so powerful. Because at the closing, you've already seen the evidence and the testimony and all of these different things. The opening is where you capture the jury's attention. I think the defense is probably winning after openings. Just my opinion.
And he had tunnel vision. He zeroed in on this person. This young man is the only possible perpetrator of that crime, to the exclusion of all other leads and evidence.
Howard went on to tell the jury that the investigation cannot be trusted.
3 years after arresting this young man and sticking him in a cell, the state looks at its case and says, oh man, this looks a little incompetent. Miramar police seems to have botched this investigation, and they call the Broward Sheriff's Office and ask them to come and look at the investigation upon which this entire prosecution rests. And he looks at it, and he says he instantly knew he had to start from scratch. I think his words were, it was the worst thing I had seen in my life.
The state's first witness was Jessica Amengor. She was a Miramar police officer working a detail at the emergency room that morning when she described Cortland Henry coming in.
So I'm sitting at the ER desk, and he comes running inside to my left, so the pediatric entrance, and he's very excited, like heightened state of alert, something traumatic or something just happened. And he's like, hey, they just shot my car, they shot my friends, like I need help. Come help me. That was the initial interaction.
And based on his statement, how do you proceed?
So as soon as I walk out the ER and I see the vehicle had multiple bullet holes on the side, I immediately radio in for additional resources because that's beyond my scope of I can handle by myself. And then asking, hey, I need additional officers, as soon as possible, urgently to respond to the hospital. I have a vehicle that's been involved in a shooting, and I can see the multiple bullet holes. And then looking inside the vehicle and see two responsive males. So I advise I have possible dead persons as well.
It's important to note Cortland Henry claims they were the victims of a drive-by, but he doesn't have any injuries. Police photographed him at the hospital. He doesn't have a scratch on him or any blood. That seems nearly impossible since there are 16 bullet holes in that SUV. On cross-examination, there was a somewhat dramatic moment when Amangor was asked this question by Melly's attorney.
Was the crime scene also inside the hospital where Mr. Cortland Henry was?
Yeah, the whole ER was shut down
Okay, so in other words, no one was allowed in that area that we saw.
unless they were needing emergency care. That would go to another room, but the ER was shut down.
So I'm real clear. Did you document the names of all the officers and detectives that responded?
No, I didn't.
So we're perfectly clear. Could you stand up? You didn't see this young man getting out of the Jeep at any time, correct?
No, sir.
The reason
All right, so very interesting. Obviously, we have the defense attorney asking on cross some questions to the state's first witness, and she is talking about how she wasn't keeping track of who was coming in and out of the ER. What the defense attorney is getting at here is the police understand that in order to keep sort of a clean case, they need to have a couple things established. They need to keep the crime scene clear, meaning they've got to make sure they don't have any sort of outside evidence contaminating the crime scene. They need to document who is involved in the crime scene, right? So when she's saying, yeah, I don't know, they're kind of coming and going, that's a problem. And then the other part is they need to make sure that what they are doing, there is a chain of custody, right? So they've got to make sure, yep, when we took the, bullet casing, it went from A to B to person C, right? They need to establish all of that because the defense will say, look, you have no idea who is coming and going. You don't know who may have tampered with this crime scene. You don't know who could have contaminated it, either accidentally or intentionally. There's no way of knowing if this evidence is the actual evidence. Very interesting, obviously not good for the state's case. But as you can tell from the openings, the state still has some statements against interest that the defendant made. And obviously there are a number of other witnesses that need to be called. I think this trial is set to go on for just over a month.
The reason the prosecution says Melly wasn't in the backseat of the car was because they said he got out of the car at 4:02 a.m. to stage the drive-by and later sent a pin to a friend to pick him up. The prosecutor showed the jury photos of the SUV where Juvie and Sack Chaser were shot to death. Blood covers the back passenger seat where Juvie was sitting. You can also see the bullet holes from the gun being fired at the vehicle. The jury also saw photos of Bortland. Police photographed him in the hospital. He didn't have any injuries from the shooting, which is mind-boggling given his claim that they were the victims of a drive-by. Police never recovered the murder weapon, but did recover a .40 caliber shell casing. The defense seized on this when cross-examining the firearms expert who analyzed all of the shell casings in this case. His name, Jorge Bayo.
Could you tell us, beyond and to the exclusion of every reasonable doubt after all of this examination, how many firearms created these casings and projectiles?
So what I can say is that one firearm fired the casings, so one firearm produced the cartridge cases that were submitted. And as far as the projectiles are concerned, I can say that two of them came from one firearm, and then the other ones could have come from the same firearm, but I cannot conclusively say that there was only one.
Okay, so there could be more than one firearm that created all of these items, correct?
As far as the projectiles, yes.
Okay, fair enough.
All right, so the defense attorney here has a much easier job, I would think, than if they had recovered a gun, because if they found the gun, they're going to find potentially other evidence that they can convict the defendant with. What the defense attorney's objective here is that state expert is doing all of the questions related to the firearm and the casing and what type of guns could have fired that. And then once he ties him in a pretzel, he wants to just poke holes in every little thing that he did wrong. And why? He is making sure that the jury understands that there could be other information that would lead to a finding of less than beyond a reasonable doubt, which means there's no conviction, right? Unless they can finding that the state has presented their case and they find that the defendant has committed these crimes beyond a reasonable doubt, they win, right? YNW Melly is creating another record sometime soon.
Now, after you did all of this analysis, were you able to determine what gun was used? to create these projectiles and casings?
No, in the absence of a firearm, I cannot conclusively say it was one or the other.
So essentially, Bayo is saying there could have been more than one gun used, which could help Melly's case. He was also questioned about determining the trajectory or angle from which a shot is fired and what variables could impact that type of testing.
And if the shooting occurred inside a car, for instance, would the arm length matter of the so-called shooter or shooters?
It could.
And whether or not the person was leaning in one direction?
Sure. Hey, we're working in a very small environment.
Okay, so there's a lot of variables that one must take into consideration
Yes.
before you say where the gun was or where the shooter or shooters were when they fired this firearm.
Right.
And if you don't take those variables into consideration, you're just giving a guesstimate, estimate of where everybody was, correct?
I assume so. I mean, I'd have to see the situation, but yes.
Okay. And you would consider that to be not proof beyond to the
Defense counsel, what's he doing? Doing the same thing again. He's saying, look, there are variables. Different guns, could be multiple guns, could be a single gun, could have been the trajectory of the gun, right? Are they pointing it close? Are they angled? Are they far away? Is the angle up, down? I mean, whatever, right? That is the exact formula for proving that the state cannot prove their case beyond a reasonable doubt.
How are you today?
Not good.
Are you cold?
No, I'm just, I don't feel comfortable.
Are you nervous?
I feel threatened.
Okay, that's interesting. So this witness takes the stand and says, you know what? I'm here today. Looks reluctant, but I feel threatened. I'm guessing she either feels threatened by YNW or the state, right? Somebody is making sure that she's here giving her testimony. I guess we're going to find out.
Prosecutor Christine Bradley said Holmes claimed she couldn't remember telling police in 2018 that Melly FaceTimed her daughter that morning. Her daughter was screaming, and Melly claimed people had fired at the SUV he was in with his friends, and he thought that they were dead. Bradley said Holmes claimed in 2018 that she saw Melly that morning and didn't see any blood on him.
You remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay, so Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time.
Holmes offered an explanation about why her statement after the murders differed from her claims now.
I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes.
All right, so we now know that it looks like the witness was feeling threatened by the state, and that is why she made this statement to law enforcement. What did she describe? She described the scenario of YNW Melly and him FaceTiming or calling her daughter and explaining what had happened and how YNW Melly was part of this shooting, right? This drive-by shooting, and basically how the state said, look, your daughter is going to be an accessory after the fact unless you work with us. Obviously, that's why she feels uncomfortable.
And in terms of the statements that you made about what happened, you don't have any recollection of that. Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't remember.
And so you indicated you hoped you were truthful with law enforcement.
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Ugh, that's the worst, right? When you have a state witness and they say, look, just saying whatever you want me to say so I don't have to go to jail. I think the jury is probably smart enough to understand that she has an interest in protecting Melly, and that if she gave the statement to law enforcement, she probably was being truthful about it, because is she lying then or is she lying now? Obviously, it sounds like she doesn't want to lie on the stand here today, so she's not going to make a definitive statement, but Juries are smart. They understand what she's doing and why she's doing it.
Christine Bradley implied Holmes had been paid to conveniently forget what she had told police.
In terms of have you ever made a statement to the effect of you were told to quit your job and the defense would take care of us?
Of the judge.
No.
Excuse me.
The defense? No.
Much comes out of it. The last question, I made a determination that was an inappropriate, improper question, and the way it's phrased was totally improper, and therefore I sustain the objection. I am instructing you that you will disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
Melly's defense attorneys were outraged by the suggestion that they or anyone else were paying off Holmes to lie.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
What the rules?
Christine Bradley in the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Oh, that is some serious cross that I think will potentially help the defense, right? Seems like it's pretty damaging. I don't know if the jury is going to have any opinion on that, whether or not, the prosecutor dragged that witness to court to make sure that she testified. I mean, the fact that the witness feels threatened by the prosecutor, not great. But obviously that's a slam dunk for the defense. Who do you feel threatened by? Right there, buddy.
This led the defense to end the week by asking for a mistrial over Holmes's testimony and the questioning by Christine Bradley.
Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial.
All right, so you all have heard that word thrown around a million times, I'm sure. Mistrial, mistrial, mistrial. You all already probably know what that means, right? But for those that don't, what's a mistrial? Hey, you guys go back to your jobs. You've been great, but you cannot get beyond this evidence that you've heard. There's no way that you can unring this bell. What's the bell that you can't unring? That the defense was paying for, this witness and sort of keeping her lifestyle in exchange for coercing her testimony or getting her to say whatever the defense wants her to say, getting her to clam up, misremember, can't recall it, whatever you want to call it. Now, a mistrial is very interesting. What does that mean? Clerk's office, right? They're going to send out those new flyers. Hey, we need more jurors. We can't continue with the jury that we have because they are tainted, right? They're used goods. We don't want them. They're like second period French. We got to drop them like a hot potato. So what do? We got to bring in a whole new group of people, which I would imagine, right? In some of these jury panels, you got to call a lot of people, right? For some of the tobacco litigation, the venire might be 700 people, right? And they're just coming in. It's like strike for cause, strike for cause, strike for cause. What's a strike for cause? If you found a defendant guilty, would you be able to sentence them to death, right? That would be a question. If you said no, death penalty is against my religion or against my morals, I could never do it under any circumstances. I don't care who it is. Strike them for cause. Got to get rid of them. That's going to happen in these death penalty cases. You need a lot of people. Mistrial, right? It's very delicate. Maybe the defense hates the jury they have. Maybe they have a jury that is absolutely terrible, right? Prior to April 2023, even if the defense had one juror that they were like, man, Miss Smith is never going to find, for the state here, or she'd never convict the defendant, we are good to go. Well, they may not ask for a mistrial. Why? Because they are confident in their one juror. Well, with this new DeSantis standard, right, 8-4, what are we looking at? Well, holy smokes. Do I have 4 people that will agree, not to convict YNW or won't sentence him to death? Yikes. That seems like a pretty tall task to come up with 5 people, right? So the defense is going to see, okay, what is this testimony doing to the jurors? Are they sitting there? Are they paying attention? Are they captivated when the defense talks? Are they nodding along, right? When the prosecutor gets up, are they grimacing? Or when the prosecutor presents her evidence, are they, sitting back? Yep. Those are all considerations. The only thing that both sides can go on is body language. So we don't know who's winning at this point. But the defense, they've got to preserve these objections. So if they lose, they can go up on appeal and say, look, this evidence was highly prejudicial. You've got to give us a fair day and a fair trial.
Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness.
For her part, Christine Bradley said these statements were attributed to Felicia Holmes from her Instagram messages.
All right, so here's what the state's talking about, right? Prosecution saying, take a look at these. These are going to tell the story about what I'm getting at. Why that line of questioning came into play, right? It says there, the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company. All right, and she even says in here, look, they can call me Ms. Snitch Bitch. Interesting, okay. All right, so, obviously the judge made a call here, right? Judgment call that this would be more prejudicial than it would be probative or helpful. So that's why we're keeping out this line of questioning. We're going to keep out, defense has tried to pay off this witness. But I don't think necessarily the state was saying the defense counsel was the one paying off the witness. I think she just said the defense. So I don't know. I guess that's up for interpretation.
Used to question her.
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form.
Judge John Murphy said he will rule on the motion for mistrial on Tuesday after the long holiday weekend. He told the defense team to consult with Melly to be sure this is what he wants, a mistrial.
Very interesting. So the defense has to go back with YNW Melly and say, hey, look, we think we've got a good jury here, right? We don't want to mess this up. We'll preserve this and continue forward. Or the defense might say, hey, we gotta see ya. Let's get out of here, buddy. Let's come back for a new day, right? You're going back to jail, but let's come back for a new day. As we know, what did the defense do? They went with option A, preserve the record, move forward, and see how it shakes out. If you like this content and you want to see more, let us know. I want you to let me know in the comments below. Do you think there was a mistrial? Do you think if you were sitting on the jury and you heard that evidence that the defense had potentially paid this witness, right? You heard that evidence, that you would be tainted, you could never find in favor of the defendant and acquit him? Or do you think that you could hear that and just, like a duck, right? Water off the back, keep on moving on with your day? I don't know. I think it's interesting. I think the defense now have their silver bullet. They can let it fly in this case, and they probably have another trial preserved quite easily. And if you guys want to learn about a little bit of class action news, follow me on my channel, The Legal Bro. Love y'all. Legal Bro out.
Big verdict.